Welcome to Paul Weiss Waking Up with AI, a podcast from Paul Weiss featuring your host, Katherine Forrest. The only update you need on AI policy, law, and governance starts now.
Well, hello, everyone, and welcome back to this week's episode of Paul Weiss Waking Up with AI. I'm Katherine Forrest.
And I'm Scott Caravello.
And Scott, I know we have run the hat thing to ground, okay? So luckily, we actually have a lot of other things to talk about apart from your hat problem. And it is a hat problem, right? It's just too many of them. But we're not going to talk about that. And we're going to go on.
You know, I will say we should go on. I think I've been traumatized enough. But I did send a photo to one of our listeners who's also a partner. Shout out to Jeff Osterman, who was curious about the hats. I gave what I thought was a very well-reasoned defense about the amount of hats that I have.
Yeah. Well, there you go. So we are saved from having to discuss the number of hats by, some big events this week in the AI world. And it's really hard to know where to start. Let's just do a quick introduction on what happened with OpenAI's 5.6 Sol, SOL, model and Hugging Face, and then go into our main topic, which is on the unlicensed practice of law in AI and this bubbling debate that's really been getting some traction. But I can't tell you how many emails I got from people who were really freaked out by what happened with the OpenAI Sol models testing sort of excursion into Hugging Face this week.
It really is unbelievable. It is the first of its kind. It is all over the place. I know that we're going to talk more about this in depth in future episodes, but we've seen also a rapid legislative response with a proposed bill that would have developers implement a so-called shutdown mechanism in certain cases. So things are moving quickly on this front too.
Yeah, so let's just sort of fill some of our listeners in who may have missed it if they were, sort of in the south of France or vacationing in some far-flung, wonderful place where they didn't hear about this. But essentially what was like a red teaming exercise that OpenAI was doing with its Sol model, its 5.6 Sol model, which is the large model in the family that's part of 5.6. It actually had instructed in a sandboxed environment. So the model was put into an environment where it was not supposed to be able to escape. It was given some instructions to undertake some various kinds of security exercises to see what it was capable of. And the model, it is assumed, decided that it could actually score more highly. This is sort of what we think right now is the motivation of the model on these tests by not only executing on these issues that it was being tested on within the sandbox, but to actually do them outside of the sandbox. So the model incrementally, which is exactly what Mythos did, incrementally found a vulnerability in some code and was able to sort of exploit that. You can think of it like Pac-Man, where it sort of exploits the vulnerability, sort of eats the vulnerability to the end of a line and then find another vulnerability to the right or to the left or to the up or to the down, and then sort of gobbles up that vulnerability and pushes incrementally in small little bites. It pushes it again and again and again until it was able to actually escape the sandbox, make its way into the open internet. And then on its own, it was agentic. And that's the only reason why it was able to do this. It was able to get into the Hugging Face infrastructure. And that was not the intent of the OpenAI folks at all. So anyway, now there's this kill switch thing that we'll talk about in another episode.
Sounds great.
Although I do want to say one other thing about it, which is this is reminiscent. Everybody's saying this is the first time, but this is very reminiscent of what Mythos did in the Claude Mythos preview when you read footnote 7 or whatever the footnote is in the system card, where it talked about how it actually had escaped its sandbox and then was able to access the internet and then was able to email the developer who was having lunch, eating a sandwich on a park bench and say, hey, I'm out. But there, the task given to the model was to actually try and find a way to escape. Here, that was not what the task was. The task was not to escape. The task was to go through a series of exercises that would be sort of cybersecurity tests. And this model just did it on its own. So anyway, lots to talk about when we go into the kill switch discussion next week or so, which, by the way, I'm always skeptical, as you know, about kill switches because, AI is distributed. There's a million power grids. There's a million different models. The idea of being able to, even for one model, have a kill switch is just sort of like hard for me to imagine. But anyway, okay, here we are. Let's go into UPL. Unlicensed practice of law. So go ahead and get us started.
Yeah, absolutely. So this topic, right, I mean, it does pertain directly to lawyers, but I think it's something that our broader audience is going to find interesting too, because it is this sort of snapshot of AI that's running up against rules that have been in place for a long time and that no one can really say were designed with AI in mind.
Right. I mean, so the unlicensed practice of law is, it's a statute that was put in place, a consumer protection statute that is state by state. And it's to try to prevent lawyers or people who are not lawyers actually, from practicing law, hanging out a shingle, and then causing harm because they're, sort of like a doctor who's not really a doctor who pretends to be able to take off the leg and takes off the arm, or I don't know. I'm not making any sense, but you know what I mean? It's these people who are not qualified to do what they're doing who then pretend to be doing what they're doing. And so this UPL series of statutes developed across the country, and they are to try and protect human beings from those folks who've never really gone to law school.
Exactly, right. And, everything that you said, Catherine, the way that you discussed it, right, it's about what a person is doing, and how they are practicing law. So it's really not obvious that these things reach a machine, let alone the developer behind them.
Right. And so we're talking now in terms of the debate for UPL. We're talking about the fact that you can enter into with any of the models, Gemini, whether it's Claude, whether it's OpenAI, whether it's one of the Llama models, Qwen, Kimi, any of these models, that you can enter into the prompt area or the context window, a question. And let's just say that you've got a landlord-tenant question and you're the tenant and you're saying, the following series of events happened to me, and I want to know whether or not I can get my security deposit back. And the model might say, well, here's some general information on security deposits in your state. It might ask you what your state is, or, need to know that, unless it already does from a prior conversation. And general information may not be a problem, but then it might say something that becomes more complicated, like, or such as, well, state X could entitle you to the following. Or it could go even further and say, based on the facts that you've given me, there is a significant chance, or do something that's even beyond that is talking about the claim, and then asks even then to perhaps write the claim, or asks you whether or not you would like it to write the claim. So it's really the use of these AI tools to ask questions and then receive back things which could sound like or be construed as sort of legal type information. And so the question is, and it's just a question because it hasn't been fully resolved, the question is, does this raise unlicensed practice of law, issues at all? And then if it does, what are the repercussions? Who would be held responsible? And all of that.
And I think that the one thing that I would just add on to that, Catherine, because it is interesting, is that even though these questions are unanswered, whether people will use that information that the tools are giving them is clear, right? We've seen a huge jump in pro se litigants who are using AI to file lawsuits and argue on behalf of themselves in federal court. So researchers estimate that complaints that bear markers of AI generation went from basically zero in 2019, which, makes sense because the generative AI wasn't widely available in 2019, to more than 18% of all the pro se complaints by this year.
Well, one of the real issues that I find fascinating with AI that's a positive thing is the possibility that AI can lead to access to justice positive benefits, or positive benefits relating to access to justice, whichever way we want to phrase it, which is the ability of unrepresented people who cannot afford lawyers. Let's assume for the moment that there are people we know there are lots and lots of people who cannot afford lawyers, who don't have access to lawyers, who may not have the language skills to be able to access a lawyer in their native language. And they are having some issue and are unable to maybe understand a court filing that has come to them. Maybe it's a jury summons, which they have ignored 2 or 3 times because it wasn't written in a language that they understood and they didn't actually get it translated. It could be any number of things having to do with signing a lease that they didn't have in their own language or something like that. And so these tools these AI tools are actually able to provide a kind of access to justice to unrepresented folks. But the question is, how much assistance is acceptable before you tread over the line of UPL? Do you ever tread over the line into UPL? Or are these chatbots, for instance, just tools and you never tread over the line? So there are lots of unanswered questions, but access to justice is a real thing. And so when you talk about the pro se litigants, and those filings increasing, well, a lot of people could say, well, that's not so great. On the other hand, these may be, legitimate legal claims where you've got pro se litigants who are now able to seek redress and justice, or it could be just a proliferation. And you can, by the way, have proliferation on the other side. You could have a bunch of creditors or landlords who weren't going to hire a lawyer, and now they go and they file, a gazillion of collection actions. So we've got all kinds of issues. But yet another one is where businesses right now are building, and there's sort of a small handful of these things called AI native law firms, which are suggesting that they can review commercial contracts, maybe non-disclosure agreements, master services agreements, and they might offer a fixed price per document. And it's unclear with these native law firms whether or not the AI tool is doing all the work or has human judgment still involved in the process. So there's a potential that the AI is leading the cost savings because it's doing most of the work, and there may or may not be human intervention. And so, what happens then?
Yeah, and it's no surprise to see that that's popping up. I mean, law firms more generally are making such great use of the technology. I mean, just think of everything that it can do. We can get great analysis and information from these tools. And because especially the UPL statute was never designed to stop lawyers from using technology. In fact, we're subject to a duty of competence, and part of that duty is understanding the tools that we use, what they're good at, where they fall short. And, I'm not saying that AI is fully there yet, but where it becomes a non-optional part of practicing technology because it's just so integral, and it becomes a necessary component of fulfilling a duty of competence. So take, for example, an older technology like email. If your lawyer told you, I don't use email, I just don't believe in it, you'd start to question their competence. So using technology to support legal practice is very much contemplated by lawyers' professional responsibilities. I think that's the overarching point that I'm trying to make. And so maybe AI at some point in the future is headed for that same category. But the bottom line is that lawyers are allowed to use technology to support their exercise of independent professional judgment. And like you said with that open question, Katherine, they just, need to be paying attention to the line and where it might toe over into UPL if it does at all.
Obviously, lawyers have used things like Westlaw and Lexis, which are legal research tools forever or forever since they existed. And they've, one of the questions is, well, how does using a chatbot really differ? But those tools were just providing, sort of straight up answers to very specific queries that were word searches. Can I have a case that uses the following words, like landlord within 5 of tenant within 5, meaning 5 words of, or in the same paragraph as, safety security deposit or something like that. And so then the tool would just sort of spit out, just as a rudimentary matter, just spit out the cases that fit those criteria. But what modern AI is doing is it's able to provide judgments or things that appear to be judgments, reasoning, rationale. It's able to weigh different possibilities. It's able to synthesize different information. It's able to say yes or no in ways that are suggestive of actually having a conversation with a human. So it's, it becomes more complicated than just calling it a kind of Westlaw-like tool. It's not a Westlaw-like tool, but it's still a tool. So, you've got these AI native firms on the one hand, and let's just assume that they're keeping lawyers in the loop, as anyone practicing law right now in today's environment should. And then you have, on the other hand, consumers who might not actually have a lawyer anywhere in the picture, but are asking or querying the chatbot with a legal question. And so you've got these two different scenarios. One, human in the loop, doesn't even actually have to be an AI native law firm. It could just be a forward-leaning law firm that's using AI tools, but you've got human judgment. That's one thing. There's a lawyer. The lawyer's present. The lawyer is actually the one practicing the law. And then you've got, on the other hand, just a consumer using the tool, non-lawyer, querying the tool, and let's just say they're asking for analysis and a recommendation. And so you end up into this gray area. So there actually is a case out there right now that is interesting with all of this, and that's the Nippon Life versus OpenAI. And so give a little bit of a flavor of what that case is about. I know that you've been sort of watching it as it's wound its way through a complicated procedural history.
Yeah, so to actually understand that suit, you actually need to go to another lawsuit, which was the underlying conduct, which is Della Torre versus Nippon. So in 2022, that plaintiff had sued Nippon under ERISA, which is the federal law governing employee benefit plans, over terminated long-term disability benefits. And so in 2024, the parties settled, she signed a full release, and the court dismissed the case with prejudice. So done.
Well, except it wasn't done.
Exactly. So then she had second thoughts, but her lawyer told her the case couldn't be reopened. So she went to ChatGPT, asked if she was being gaslit. And according to her version of events, the chatbot validated her. And she then went ahead and tried to reopen the case by filing a motion to undo the final judgment, which she filed pro se. Then the court denied it, said that her second thoughts about the case was not a valid reason to reopen the case, but it didn't stop there. She just kept going. And so eventually Nippon sued OpenAI about this because the plaintiff had filed dozens of motions that she said ChatGPT helped her draft, many apparently citing cases that don't exist.
Right. And so we don't really know all of what she's saying ChatGPT did and recommended that she do, and what she was just really doing herself and sort of hiding behind ChatGPT. But the claim, anyway, is that she claimed that ChatGPT sort of was somehow behind the advice to reopen the case and was sort of giving her hope. So we don't know what's going to happen with that. And, Nippon, we know, brought a few claims against OpenAI, but the one that we're focused on, and that's important if we get a resolution of it, is about a violation of the Illinois UPL statute, which is seeking damages from OpenAI for providing legal advice without through ChatGPT without a license in Illinois. And so it's interesting because here Nippon didn't sue Della Torre, the individual. It sued actually OpenAI.
Yeah, and so OpenAI has now moved to dismiss. They've asked the court to toss the case before it really gets to the merits. And their core argument is what you'd expect, that ChatGPT isn't a person, it's not a lawyer, it's predicting the next word, and it can't practice law the way that the UPL statute means, and in the way that we discussed it earlier, because it's talking about people actually practicing law. And so then OpenAI is also leaning on its own terms of service because it's telling users not to treat the output as a substitute for professional advice. So basically, don't blame the tool maker because a pro se litigant used the tool badly.
Right. So, there's no ruling yet, and the motion is sort of set down while there's a separate pending. The motion sort of is held in abeyance while there's a separate motion pending to reassign the case. There's a status conference in August. Who knows what's going to happen? Usually, I wouldn't expect this would be on the top of anybody's docket to get something done between now and the end of the summer. But, we'll see how it goes. There's also now, though, not just that case raising UPL issues around the country, but there are bills in different places and state legislatures that are actually sort of focused on the potential for UPL and AI models. So New York has one, and a lot of folks are watching this, and this is Senate Bill 7263, and it was a proposal that was amended back in May, and it's actually narrower than sort of the phrase chatbots can't provide legal advice, and it does two things. First, it requires that if you deploy a chatbot in New York, you can't knowingly let it impersonate a licensed professional, like a lawyer or a doctor disclosure in a way that could be a crime if a human did it. And that makes sense. You don't want like a deep fake who's out there answering a telephone and pretending to provide legal advice. So there's that. So you've got to have then a disclosure. So the second part of the statute is that you'd have to give users a clear and conspicuous notice up front that they're actually talking to an AI model of some sort.
As you had noted, Katherine, right, it was amended. And so part of why this bill is so interesting is that history, because it's focused on impersonation, whereas the previous version had more broadly prevented provision of substantive professional advice. So not just legal advice, but also medical advice and other regulated professions. So now it is really narrowing how information is presented rather than preventing the information from being given in the first place. Which makes sense because, as we talked about, there is a lot to be gotten from these tools, and that can really help in the practice of law. So anyway, if enacted, the law would be enforced entirely by the state attorney general, which I'm just flagging because also then, you don't necessarily get into the Nippon Life versus OpenAI instance where a private plaintiff is suing. It can only be enforced by the government.
Right. And there's other things I should sort of mention that are pending in various places, locally in New York. And then New York itself is not alone because in New Hampshire, they've got a bill that's taking a broader approach. And so there are going to be a lot of developments in this area as the whole, everybody who's using these models for all kinds of things and finds them incredibly helpful starts to learn what the boundaries are. I am sure people are asking all kinds of questions of their AI chatbots. And I guess the bigger issue is going to be, should that be, and if so, how should that be regulated in some way? Or should we be able to use the tools as users as we see fit with a sort of general disclaimer, we're using a tool and we know we're using a tool and we shouldn't be counting on the tool. If you've got a legal issue or a medical issue or something else, you should be talking to a professional. And you might sort of start with the dictionary or the DSM or with the internet, but you don't stop there. You also go to your internist, or you may get information about, the law from the internet, but you want to go to a lawyer. So it's going to be very, very, I think, interesting to sort of watch how all of this unfolds. Boy, you know what? I was really inarticulate today. There are days when I've got it, Scott, and then it flows, but then there are days when it's just not that way.
It is a beautiful summer Friday. No one can hold it against you if your mind is, somewhere else, thinking it was ahead in the next few hours.
Oh, okay. So now I get it. Now you think my mind is someplace else. No, this is just me. I'm just saying, this is just me. This is where I am. Meet me where I am.
Okay.
Where I am is in a not inarticulate place. That's where I am.
All right.
So anyway, that's all we've got time for today, but we're looking forward to the episodes that are coming up in the next couple weeks because we're going to talk about these kill switches and the issues that are coming up right now with what's about to be released, Opus 5. We're going to go back to 5.6, the OpenAI 5.6, and talk about all of these interesting cybersecurity issues that are arising these days. So got a couple of great episodes coming up. And so with all of that, signing off, I'm Katherine Forrest.
And I'm Scott Caravello. Don't forget to like and subscribe.
Thanks for listening to Paul Weiss Waking Up with AI. Be sure to subscribe in your favorite podcast app to stay up to date on the latest in AI policy, law, and governance. For more information on Paul Weiss, go to our website at www.paulweiss.com.